Today on Off the Clock, we're going to talk about the U.S. Supreme Court cases that impact employers the most, that were just issued at the end of their term. There's a case on religious accommodations and also a case that struck down affirmative action. In the university and college context, we're going to talk about how it might apply to employers.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
I'm actually really excited for the episode today because I feel like I'm going to learn some things from you.
That doesn't happen very often.
It happens a lot, listeners. It happens a lot. No, I know that you really have been following these two Supreme Court cases and thinking about how they matter to employers.
Well, it's not often we have United States Supreme Court cases to talk about in the employment context.
That's right.
We've been doing this podcast a few years now, and there hasn't been a lot of discussion about what the Supreme Court has done or hasn't done. So they were very busy at the end of their last term getting lots of opinions out. It felt like every day or sometimes twice a day, right? I got like a breaking news email from one of my news sources, not quite as bad as COVID when things kept changing, but it was quite fun. When I went to law school, after all, I assumed I'd be reading Supreme Court cases all day long and talking about
every
them.
day.
And then as practicing attorneys, we get to
doesn't happen a lot.
Very little of that. So let's just jump in. As I mentioned, there's two cases that are of primary importance at getting a lot of attention. The one that applies to employers the most straightforwardly, I should say, is the one that got the least amount of attention because it came out during some other big news cases, but it impacts requests for religious accommodations. Did you hear about
I did,
that one?
and this really is important for our listeners to understand. This is a big one.
This is something that impacts the advice we give to employers on a day-to-day basis. Therefore, it impacts our employers on a day-to-day basis, right? So we really have to know about this. So let's just set the stage.
Yeah, what's the case about?
For a moment.
Tell us.
The case is about a request for religious accommodation that was brought by a U.S. Postal Service employee, an observant Christian evangelical who observes the Sabbath as a day that no work shall be performed.
Okay.
And the U.S. Postal Service wanted to schedule him on Sundays.
Okay.
Now you may be saying,
If they don't
do you get
deliver mail on Sundays, what's the problem?
I don't get mail either, but as an additional revenue generating activity, the U.S. Postal Service has started doing Amazon deliveries and on Sundays. Okay, so it's not
well,
mail.
that is very important that we get our Amazon packages on Sundays. So
correct. By not working Sundays, he worked in a very small district, right?
Oh, okay.
And so it meant that his coworkers, which were limited in number, would have to pick up those Sundays. And while they didn't have a religious objection to working on Sundays, they just kind of didn't want to.
They just had a regular objection.
They just had a regular, I'd rather sleep 1 day a week. Okay.
I see.
And so his request was denied under the standard that existed before the Supreme Court case. Remember, the standard was for religious objections if it was anything more than a de minimis inconvenience or cost to the employer could deny it.
Could say no, right? That was, in other words, that was the standard for what we call undue hardship under Title VII, right?
Yes.
And I remember in COVID, of course, we talked a lot about religious requests for religious accommodations. And we talked a lot about undue hardship. So our listeners may remember hearing us say the standard for undue hardship under Title VII is much lower. It's a de minimis standard in comparison to the ADA.
Anything more than an inconvenience,
Right.
in other words, was enough to be an undue hardship when considering a religious accommodation.
So using that old standard, I would say the Postal Service had a decent argument, right?
Absolutely.
That the inconvenience to those few other coworkers to have to work more Sundays, right? To sort of take that other employee's turn working on Sundays. I would say they've got an argument that that's more than a de minimis inconvenience.
Right. It was a decent argument under existing case law.
Okay.
Before COVID vaccine mandates, most religious accommodation requests in cases did have to do with scheduling. So that area of case law was fairly well developed.
Yeah.
And that was a decent argument. If it inconveniences the colleagues or it increase overtime costs, et cetera, right? That could be more than de minimis. So now we have a Supreme Court, and that has changed, right, in political makeup. And so we have organizations that want to test some of these long-held beliefs or developments in case law. So they brought this all the way up to the Supreme Court, and the Supreme Court
took the case
and changed the standard
Yeah.
for what is an undue hardship when considering a religious accommodation.
Okay, so let's just pause there and make sure our listeners are hearing this, right? The law has changed, the rules as they know them has changed now.
Yes.
Okay, that's
Yes,
that's
I feel
a
like
big
I
deal,
need to do
right?
like one of those like sound effects.
Pay attention.
Right. Beep, 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 beep. Breaking news, like back in the 40s. Right.
Okay.
Yes. This is not just chit chat, right? Not that normally what we do is just chit chat, but this is not. This is news, a change in the law. We did put out a client alert about it, but people should really be paying attention to this.
And so then, of course, that begs the next question, which is, what did it change to?
So the new standard, I'm going to need my reading glasses.
Yeah, right.
Because I haven't been talking about it much yet because it's brand new. The new standard is it is an undue hardship only if the accommodation would result in substantial increased costs in relation to the conduct of that particular business. So substantial increased costs
That's
in
plural.
comparison to the whole business. So for our larger employers with a decent amount of receipts, it's going to be very difficult. Let's just be blunt about it. If we're talking about dollar and cents costs compared to the total company revenue, it's just going to get a lot harder.
That's
right?
a very difficult argument to make. Can I just take a time out for a minute and just comment on the new standard and just share
If you must.
perhaps an annoyance that I have? I mean, I think many of us weren't surprised that the Supreme Court raised the threshold for undue hardship with regard to religious accommodations, right? Many of us kind of thought that's why they took the case up and that they were probably going to change it. Some of us optimistically thought that they would make it easier for employers by adopting the ADA standard, right? So that we could all have one common understanding of what undue hardship is and maybe some context
Wouldn't that
for
be nice?
it. But no, they didn't do that at all. They instead made up a new one.
Job security for us. Let's stop complaining.
So as we're looking at these words, substantial increased costs in relation to the conduct of the particular business, as we sit here today, there's no additional guidance or case law telling us how to interpret that yet, right? So we're just left with the words.
We're just left with the words, and the way these things happen is the Supreme Court case, or the Supreme Court issues one decision, right, which is obviously just one opinion, and then what happens is case law in the district court and the appellate court start fleshing out what Supreme Court cases mean, but it takes years and years and years, right? And the EOC might make a statement or issue guidance to flesh out what the EOC thinks it means, but that's not necessarily binding law. Right? So really two more things to think about. One is, what does that mean?
Yeah.
Substantial increased cost. And Sarah, how does it compare to the current ADA standard?
Right.
What is the current ADA standard and how is this different?
Yeah, well, for me, the fundamental question is that word costs, and it is plural, right? If the Supreme Court is using that word to mean only financial consequences or the money that the business would have to spend in order to provide that religious accommodation, I think it is going to be extremely difficult for any mid-size or larger employer to ever meet that standard.
Right.
I talk to clients a lot about the undue hardship standard under the ADA, and some of our listeners have probably even heard me say, just skip over the financial piece of it, right? And let's go to the other considerations for undue hardship, right? The disruption to the business, the impact on coworkers, et cetera, because it's so difficult to show substantial cost to any organization of a significant size. And when you think about, for example, in the case that led to the decision, you have one employee who's requesting not to work on Sundays. What if there was financial consequences? It probably may be a bit of overtime for that one employee, but the U.S. Postal Service is not going to be able to show that payment of overtime to that one employee.
Right.
So it all comes down to, it's going to come down to what the Supreme Court meant when it used the term cost. Does it mean cost in the strict sense that we often use that term, or does it also include other impacts to the business?
Right. And that we just don't know yet.
And they didn't say in the decision.
When employers are getting requests for religious accommodations, it's going to be a case-by-case risk analysis. And,
that's right.
Really analysis, right? It's going to be a little bit different than it was before. Another way it might be different is we often scooted by fairly quickly the part of religious accommodation requests that requires the person to have a sincerely held religious belief. Yeah. Right?
Because it was so easy to show undue hardship. We didn't bother spending a lot of time talking about that.
And let's just be honest, it can be uncomfortable. It can be alienating between you and the employee to talk about their personally held religious beliefs, right? It can be, can be uncomfortable. For people to talk about religion. A lot of us were brought up saying, right? You don't talk about money or religion. So we just move past it fairly quickly. Now, in some cases, again, you really are going to want to hit the pause button and think about things carefully, but you might want to take a closer look.
Lean into that.
At whether the person has a sincerely held religious belief before we get into the undue hardship discussion.
Okay.
Right? So one last point on this. A lot of folks are predicting increased requests for religious accommodations.
Which we were already seeing increased requests before this decision.
But now folks are going to be encouraged, right, to make requests, because they're more likely to be honored. And did you know that religious accommodation cases is the fastest growing type of employment litigation right now?
Yeah. Well, we watch our local court filings, and I can attest that is certainly the case. I see more religious accommodation cases. Most of them, by the way, coming out of COVID.
Yep.
And denial of vaccine, of requests not to be vaccinated based on a religious belief. As
we have also seen, and we've talked about on another podcast, objections to DE&I training also is on the rise. And so now with this case, we may see more of those too. Okay, so I think
interesting.
So religious. The bottom line is request for religious accommodations. Hit the pause button. Remember, there's a new standard. Then go look it up because you're not going to remember the exact words from this podcast. And call your favorite employment lawyer to work through the details.
Sure. And the other thing I would add is most of the time policies don't state clearly what the undue hardship standard is. But in COVID, I did see some employers go into that level of detail.
That's a really good point.
So employers should probably make sure that they don't have something in writing, whether it be a policy or something else, that refers to the old undue hardship standard that is no longer active.
I would see it on forms where employees would actually request.
Yes.
Right? Some employers would include the standard. Yep. That's a very good point. All right, so should we talk
about the second case?
Okay, so this is an affirmative action case with no direct application to private employers.
Right, because it involves colleges and universities, right?
Yes, there's this, and this is something that a lot of employers have never really paid attention to, frankly, because it doesn't specifically apply to them.
Unless, of course, they're a college or university, right?
True. You all have been paying attention. That there is this whole unique kind of separate, siloed, if you will, chain of case law that talks about affirmative action in the college admissions, not employment, admissions setting.
Yes.
And in that setting only.
Right.
And the Supreme Court has allowed, limited with some guardrails, but affirmative action programs. And by that, let's get the word straight.
Yeah, let's talk about what we mean
Because
by
I
affirmative
think there's a
action.
lot of confusion out there. That's what I'm seeing since this case. Where colleges are allowed to consider race, explicitly consider race, when deciding which students to admit.
In other
or not.
words,
It's an exception. It's an exception to all of
they
our
can do it. And
rules
it can,
that say you can't.
and that rule means that colleges and universities have been able to rely simply just on the box that an applicant may check when they say, I am of X race, not looking beyond that whatever box they check. They can give some weight
Correct.
to the answer to that question.
Well, they
have been able to.
They have been able to.
And you're going to tell us.
Spoiler alert.
Right, exactly. You're going to tell us what's changed and how that's changed.
Spoiler alert.
Okay.
First of all, this came up much the same way the other case did, right? There's a new makeup for the Supreme Court. So we're seeing a lot of challenger cases, right? Cases that would have kind of been dead on arrival, frankly, under previous courts, or the court just would never have agreed to take it on in the first place, right? We're now seeing a Supreme Court that is willing to take on some of these big social, political issues. This is just one more example. So this case involved the University of North Carolina and Harvard, two exclusive, very hard to get into institutions, both said out loud they had affirmative action plans, right? Like
They
many
did
other
consider
exclusive
race
schools.
as a separate
And they claimed they were within the guidelines that the Supreme Court
had laid out.
The Supreme Court, in considering the case, did say they thought they may have been over those guide rails in some instances, but regardless, affirmative action programs in higher education for admissions is no longer acceptable. The rationale that colleges had used, which had been approved by the Supreme Court, which is diversifying the classes of students, the cohorts of students, that was the reason, that was the compelling interest to create this exception, right? To a country where we largely say you shouldn't consider race, right? In employment, education, et cetera. We're going to make a narrow exception because it's so compelling to diversify the cohorts of students.
In the educational setting.
In the educational setting, and the Supreme Court said that is not a compelling interest.
Okay. So they changed their
Diversifying
mind,
the student bodies is not a compelling interest enough to override, right, the Equal Protection Clause, which says you can't discriminate, essentially,
I see.
based on race.
So just like the first case we talked about, the religious accommodation case, this is a case in which the Supreme Court changed the rules.
Yep.
Okay.
New rule, made lots of news. Probably people heard about it. And that's why we're discussing it, frankly, is because after the case came out, I will tell you my first instinct was, well, this doesn't apply to 99% of our employers, particularly in the employment context, right? So it's interesting from an intellectual point of view, but probably not good fodder for our podcast, right? Whenever something comes out, I think, should we talk about it on the podcast, right? That's my first thought. But then within that same day, President Biden started talking about how this might impact private employers. The New York Times, others started writing about the potential impact on private employers, and employers started putting out statements, right, about their reaction to the case and how it may impact their DE&I programs. So we should talk about it.
We should
and how
talk
it
about
might apply. But just to be clear.
Yeah, I was going to say, can we start with the starting place for employers and a reminder of what their current requirements are? Because as you mentioned at the beginning, this case involved an entirely separate line of cases for colleges and universities that had allowed consideration of race in their application process, right?
Yes.
Okay, so let's talk about employers and what the current law is for them.
So the current law as for employers has not changed. And it is, Title VII under federal, right, and then most states have corollaries, it is unlawful to consider race in employment decisions.
Correct.
There is a small exception to that For bona fide affirmative action programs, in my experience, those are very rare. And this is different, by the way, than federal contractor affirmative action programs. This is the type of affirmative action program where you have to prove a historical racism, discrimination,
Right.
right,
A
existed,
pattern.
and you are doing this to correct that proven pattern, right, that existed in your industry. It's very unusual.
It's very unusual, Bev. So
if you have one, you know it. I will
was
say
gonna
that. So in case listeners are thinking, well, do we have one of those? Is that part of our DNI? If you have one, you know you have
would
one
know.
because you would have had to go through quite a lengthy process, and there would be literally something on your applications and whatnot in your consideration. So if you don't know you have one, you probably don't have one. Okay,
So other than that,
that small exception.
employers cannot discriminate on the basis of race, and that includes any race, meaning
Correct.
you cannot discriminate in favor of somebody who's not in a racial minority. That's we often
Yep.
refer to that as quote unquote reverse discrimination cases in
Yes.
which maybe a white or Caucasian employee will allege that they didn't get hired or promoted because of their skin color, because they are not a person of color, they are white or Caucasian.
And those cases have
alive
been
and well.
brought. Yeah,
Right.
they were not uncommon before
Right.
this decision, and they will continue after this decision.
Okay.
We may see an uptick in them because of the increased awareness now.
Okay.
So that is a potential impact on employers. It doesn't mean the law has changed for employers, but practically speaking, we may see an uptick in those kinds of cases, right?
Yeah.
But this case itself does not govern private employers. It's
Right.
still Title VII and the state law corollaries, right? You should not be considering race when
Okay.
making employment decisions.
So does the decision, though, impact how employers might be or should be thinking about diversity or DE&I in their workplaces?
Well, hopefully this is already part of their DE&I, which is we don't consider race when making employment decisions. We can still do other things as part of our DE&I programs if they're already in place and organizations want to continue those. For instance, diversifying the applicant pools. That's still perfectly fine as long as we're not using race to make an employment decision,
okay.
right? For instance, people that hire from colleges, right? Going to colleges that have a higher percentage of minority
Okay.
students or trade schools, et cetera, right? Holding job fairs in communities that may have higher percentages,
Okay.
right, of minority persons instead of just holding them in predominantly majority towns, things like that.
I see.
But actual employment decisions before this decision and after should not be based on race. What should employers do in light of this decision? I think this is a good time to take out the DE&I policies, not just the written policy. That's important. We know we like our written policies, but what we're doing in practice.
And how we're talking about
And
it, right?
the words we use, the phrases we use, what we are communicating to our workforce, because there is a significant part of every workforce that has a feeling that perhaps D&I has gone too far, and they will see this case as support, right, for that belief. And so while nothing has changed, it's a good time to kind of brush the dust off and make sure that we're doing things as we frankly always should have, but that we're being careful in our word choice, et cetera, and in what we're actually doing and how we're actually making decisions.
Right. So what I hear you saying is there's nothing in the new Supreme Court decision that says that diversity, equity, and inclusion can't be an important part of an employer's mission.
Correct.
Right? There's nothing in there that says that. But when we think about how we use, for example, the term diversity and what that means to us, we need to make sure that we're not saying that's only based on racial classifications, right? We don't mean diversity is important to us and therefore race is going to be a consideration when we're making employment decisions.
Should never be a consideration when I'm making employment decisions.
Got it.
This
That's tricky. I mean, can I just say that out loud? That is a tricky thing to balance.
It is.
how we talk about it, how we write about it, et cetera, for an organization. I mean, and it takes, I think, some pretty careful thought and some open conversations among leadership teams as well to make sure everybody's on the same page.
I agree. And frankly, I would have hoped those conversations took place
Yeah.
anyway, but we're sometimes, right, we get ahead of ourselves, we're busy, et cetera, et cetera. So this is just a good opportunity
Agreed.
to come back to it
Okay.
and make sure our house is in good order.
Great. Well, thank you for being our Supreme Court reporter. I appreciate it. You and Nina Totenberg, right?
Oh, comparing me to Nina Totenberg is the nicest thing you possibly could have said. Next time I'll have to bring my Nina Toten bag. Just my favorite fundraiser gift ever. Okay, with that, we'll say goodbye.
With that, thanks.
Bye, Sarah.
Bye.